Before you file your patent application, you need to know this. The U.S. Patent and Trademark Office, or USPTO, is a graveyard for brilliant ideas killed by paperwork, bad timing, and simple legal errors. I'm Julie King, a rock and horror-loving patent attorney, and I'm here to show you 6 legal sins that send even great inventions to the patent graveyard. I'm talking about mistakes that can cost you all your international rights, invalidate your patent before it's ever granted, and waste tens of thousands of dollars and a lot of time. It's smarter and cheaper to prevent a nightmare than to cure it. Let's face the horrors you must avoid to keep your invention alive and rocking. Patent application sin number 1 is oversharing, the self-inflicted wound from sharing your invention before filing. Committing this sin creates the horror of losing international patent rights on day 1 and U.S. rights in a year. Inventors love to talk about their creations. They're excited about them and they want validation, investor feedback, and early market buzz. But the very first time you disclose your invention publicly, whether it's on a social media post, a trade show demonstration, sales pitch, or a tech journal, you start the clock ticking on your patent rights. In the U.S., you have a 1-year grace period from the earliest public disclosure to file a patent application. File that application 12 months and 1 day after your first public disclosure and no patent for you. Now, in some foreign countries, there's no grace period of any kind. Any public disclosure before filing a patent application can cause you to lose your rights in valuable markets across the globe. In many other countries, that deadline is just 6 months. Here are the actionable takeaways to prevent committing the patent application sin of oversharing. For U.S. rights, file your non-provisional patent application, or at least a detailed provisional, before you publicly use, sell, or disclose your invention. Then if you did file a provisional application, don't forget to file the non-provisional application within 12 months of the provisional filing date. For foreign rights, check the grace periods and file your international applications before those grace periods expire. That may mean filing before any public disclosure. Patent application sin number 2 is redundancy, the dead-on-arrival patent application. Committing this sin creates the horror of wasting money on a patent application for an invention that lacks novelty. Inventors often submit patent applications assuming their idea is entirely new. However, the number 1 reason patent applications get rejected is prior art conflicts. Novelty, or newness, means your invention must be substantially different from anything else known to the public anywhere. Prior art is anything previously patented, written about in a publication, or sold in the open market before your filing date, and even in a foreign country. Skipping a professional prior art search, also called a novelty search or patentability search, can lead to costly rejections, wasted R&D, and lost filing fees. Now, lack of novelty doesn't necessarily mean your invention itself is dead on arrival, but it does mean any patent application for it is. Whether you can still make and sell your invention is what a freedom to operate patent search looks at to see if your invention may be infringing on patent rights in effect in the countries where you want to make and/or sell it. Here are the actionable takeaways to prevent committing the patent application sin of redundancy. Have a professional, thorough prior art search done early. A patent lawyer can identify existing products and determine if your invention is different enough from what already exists to meet the novelty and non-obvious requirements, which I will talk about in sin number 4. Patent application sin number 3 is omission, the ghostly details of a vague or incomplete application. Committing this sin creates the horror of having an application refused with no ability to fix it. A patent application must contain a complete disclosure of the invention. If the written description contains insufficient or vague detail, it will be rejected for lack of clarity or for not sufficiently enabling the invention. One of the 3 most prevalent reasons patent applications are rejected is insufficient disclosure of the details of the invention. The application must provide adequate details that would allow a person skilled in the relevant field to understand and replicate the invention. Here's the fatal flaw. Once filed, new material can't be added. If you leave out vital components, you can't add them later, which potentially makes your application and claims worthless. And that last point is the kicker. It's extremely difficult to overcome a rejection for insufficient disclosure because of it. You usually can't just start over by filing a new application either, because by the time your application is examined and refused, that 12-month public disclosure window may have expired depending on what you did with your invention between filing the application and the time it got rejected. You really need to get the level of detail right the first time. Here's the actionable takeaway to prevent committing the patent application sin of omission. Include detailed descriptions, drawings, flowcharts, and technical data in the patent application, including the provisional application. Your goal is to leave no room for ambiguity or vagueness. Patent application sin number 4 is obviousness, which is just an expected variation. Committing this sin creates the horror of failing the person of ordinary skill test. Even if your invention is new or novel, you may not obtain a patent if it's deemed obvious. And here's the test. The invention must not be an obvious extension or modification of existing work in the eyes of a person having ordinary skill in the relevant field. Here's the trap. What seems like a brilliant leap to you, if you aren't someone who works in the field of the invention regularly, may be considered an obvious combination of existing solutions to someone who does. Here's the danger: rejection. If the differences between your invention and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made, the application will be rejected. But here's actionable takeaway to prevent committing the patent application sin of obviousness. When drafting claims, emphasize the unexpected result or the technical difficulty that your invention overcame. To try to avoid a rejection for obviousness or argue against one, your lawyer must argue that your invention represents a significant leap beyond what has been previously achieved for good reason. Patent application sin number 5 is impersonation, using generative AI and claiming you're the inventor. Committing this sin creates the horror of using an AI tool to help you invent and claiming you're the inventor for the parts it invented. With the rise of artificial intelligence, or AI-assisted inventions, the rules around inventorship are more crucial than ever. The rule, per updated USPTO guidance in November of 2025, is that only natural persons, human beings, can be inventors or joint inventors on U.S. patent applications. AI systems, including generative AI, are explicitly treated as tools by patent law, like laboratory equipment or software. Now, they may assist in the inventive process, but they cannot legally conceive the invention. The fatalities from this patent application sin are caused by rejection and invalidation. Applications listing an AI system or other non-natural person as an inventor will be rejected under 35 USC sections 101 and 115. If you're claiming priority to a foreign application, there must be at least one human in common with that application in your application. Now, while the USPTO examiners may not look into which parts were invented by a human and which parts were created by AI, if a dispute over the patent ever arises, you can bet opposing counsel will look into it to try to prove the patent is unenforceable or invalid. Here are the actionable takeaways to prevent committing the patent application sin of impersonation. Always document the human-driven conception, how the natural person selected, specified, and integrated the AI-identified features into the claimed solution. It's important to keep good notes about your inventive process no matter what, but if you're using AI to help you, document that and how you had it assist you. Print or download your AI use history and conversations for your records. Patent application sin number 6 is amateurism, the mad scientist mistake of self-filing without a patent attorney. Committing this sin creates the horror of DIY filing that results in a worthless patent. Many inventors do file their own patent applications, hoping to save time and money, but this is often the costliest mistake of all. DIY filing often results in vague, weak, or incomplete patent claims that are either rejected or, worse, easily worked around by competitors. Claims define what your protection is. If they aren't drafted properly, your protection won't be what you're hoping for. Many DIY filers fall into the provisional pit. A provisional patent application is only as good as the detail it includes. If you don't describe the invention with the required detail, the provisional application is worthless when you file the more detailed non-provisional application, which means you lose your early priority date. Patent attorneys specialize in translating innovative concepts into the precise, technical, and legally required language of the Patent Office, and they work with you to protect the important innovations. Here's the actionable takeaway to prevent committing the patent application sin of amateurism. Partnering with a patent lawyer is an investment in significantly increasing your odds of receiving proper legal protection for your invention and the enforceable asset of a granted patent. The attorneys know the nuances needed. Don't let your brilliant invention become another headstone in the patent graveyard. Intellectual property is one of the most terrifyingly useful tools you have. Having a professional in your corner is the best way to avoid committing these legal sins. If you're ready to build a frighteningly powerful business and brand, book your consultation with me at kingpatentlaw.com. I serve entrepreneurs across the U.S. Finally, this information is for educational purposes only, isn't legal advice, and doesn't form an attorney-client relationship. That means I'm not your lawyer. Please seek the counsel of a licensed, experienced attorney, perhaps me, for your specific legal needs. Avoid the legal horrors and keep rocking your IP.